Hello everyone, I'm Ashley Whyte and I'm here with my colleague Lucy Hendy from the AML-CFT division to spend some time talking to you today on Introduce Business. So just to go through our agenda. Firstly, we need to point out that what we are saying today does not constitute legal advice or guidance. It is feedback on some of the scenarios provided in this area and then a detailed explanation of the code. We're going to begin by providing some background on the Introduce Business paragraph of the code and why it was brought in. We're then going to look at some of the different terminology in this area used by both industry and our handbook and explain some of the differences. We'll move on to have a look at the definition of introducer in the code and how to interpret that. We'll also explore the difference between an introducer, which is under paragraph 9 of the code, and an eligible introducer, which is under paragraph 19 of the code. We'll then go on to analyse some scenarios which have been provided to us by industry. In terms of outputs from this session, we'll cover that towards the end, and also any questions which can follow by email. So before we go into the detail, we thought it would be helpful to spend a few minutes explaining the background to this area of the code and really why we have Introduced Business. In 2016, we underwent our mutual evaluation by Moneyval. A key theme coming out of our report was that the assessors had come to the conclusion there was a prevalence of chains of customer information and due diligence in business relationships. Essentially, that when onboarding a customer, there may be several chains or layers that the customer information and due diligence has gone through before it reaches the relevant person taking on that customer in question. The assessors concluded there was just not enough scrutiny by the entities of where the customer information may have originated from. Those taking on the business were just really taking it on face value. This was an area that was determined by Moneyval to be a key issue, and it was one that contributed to our lower rating in the area of customer due diligence. In turn, this was one of the areas that pushed us into the enhanced follow-up process with Moneyval. It also put us in the observation period, which is where you have to demonstrate positive and tangible progress within a year in order to exit the observation process and to not be grey-listed. Therefore, it was imperative that this was an area we addressed. The Isle of Man gave a commitment to the FATF in October 2018 that we would fully meet the requirements of this recommended action by Moneyval, which is included there on the slide in italics. The recommended action was that the authorities should further limit the circumstances in which CDD information and evidence of identity presented by a third party can be used, including where that third party has collected information from another party, an information chain. The island exited the FATF process for greylisting on the understanding that this point and two other outstanding matters would be dealt with in cooperation with Moneyval. Otherwise, the Isle of Man will be referred back to the FATF for further consideration regarding greylisting. Therefore, the code wording that was brought into the 2019 code was written. We had to do this very quickly, and it was workshopped as best we could with industry at the time, and the wording was then agreed to by Moneyval before we brought it into law. We do appreciate this is a complex area, and we have tried to keep our guidance as detailed as we can to assist firms. Also, providing diagrams. We'll discuss the guidance later on today as we work through the slides, as well as providing some scenarios that we'll talk through. So, I've talked about the background and the reason we had to bring in this particular area of the code. It was to address concerns raised by Moneyval regarding potentially numerous third parties providing customer due diligence and information during the establishment of the relationship. So what is Introduce Business? The paragraph itself, paragraph 9 of the code, is referring to a customer being introduced to an Isle of Man relevant person where elements of the CDD are being provided by another party or numerous parties. Essentially, during the establishment of the business relationship, where there is another party providing customer due diligence to the Isle of Man relevant person, this party must be risk assessed, and the steps in paragraph 9 must be followed to understand the chain that is in place. As it states on the slide, there could be numerous sources providing CDD to the Isle of Man relevant person, and during the establishment of the business relationship, these parties must be risk assessed. This paragraph of the code is concerned with the onboarding stage prior to the business relationship start date. It is essentially to do with the introductory stage at the outset of a business relationship. As with any new legislation, it has taken time to bed in as we have dealt with various queries and we've considered scenarios as part of our supervisory work. Following this, and looking at some specific queries from some firms, we updated the AML CFT handbook in December 2023 to clarify our expectations in this area. Since this update, we've been made aware by some people that the new wording is causing some additional confusion and is suggesting a difference in approach. Just to confirm, we haven't changed the approach, we have tried to add additional clarification. We appreciate this is a complex area and there has been some difficulty in understanding this topic, which is now why we are trying to do some increased outreach in order to improve understanding. We have mentioned a few times about the provision of elements of CDD, so just to explain what we mean. Customer due diligence is defined in the code as the measures taken in numerous code paragraphs in order to identify and verify the identity of your customer. As per the slide, it is not exhaustive. It could include the provision of the information or evidence concerning a customer's identity, source of funds or source of wealth requirements, helping with the provision of customer information, for example, via an application form. It's not just in relation to verification of identity. As we explained previously, the introducer paragraph is concerned with the onboarding of the customer and the gathering of the CDD during that establishment phase of the relationship. I'd also like to draw your attention to paragraph 6.3e of the code, which is in relation to customer risk assessment. And this is where it brings in any other third parties during that life cycle of the business relationship. So just moving on to look at some of the terminology that we use to describe the scenario where another party is providing elements of customer due diligence. Firms may use different terms. Examples include agent, intermediary, representative, etc. Within our handbook, we use the term introducer. Whether the person is an introducer depends on their role in the business relationship and what level of customer information they're providing and at what stage of the onboarding process they're involved in. It doesn't really matter what terminology you may use internally, as long as it's clear in your procedures and controls where an introducer is used and it's in accordance with paragraph 9 of the code. We've also just put the definitions on the slide there of both introduced business and introducer. So what is the difference between an introducer and an eligible introducer? This query came up a lot when paragraph 9 was first introduced. This was understandable as eligible introducers were historically the only introducers referred to in the code. The paragraph 19 requirements were not changed in the 2019 code, and while testing of the eligible introducers' procedures, controls and CDD information and verification documents has always been required, we have seen a decline in the use of the eligible introducer concession, perhaps because of the onerous testing involved. It is, however, still used in some areas, but the difference primarily is with the EI, the eligible introducer, you won't necessarily hold the CDD documents and verification of information and identity. You're relying on somebody else to hold these documents. Whereas in paragraph 9, you will hold the CDD, some of which you may have obtained yourself and other parts you may have obtained from a third party or numerous third parties. Paragraph 9 is absolutely distinct from paragraph 19 of the code. However, even where you are using the EI concession, you are still required to risk assess the customer. That CRA must of course consider who has met the customer and whether there are any third parties in the CDD process. Paragraph 19 of the code is lengthy, so we cannot cover everything here, but the slide does show some key points to demonstrate the difference between paragraph 9 and paragraph 19. Moving on to look at a referral. A referral is really how it's described in our handbook. It's where a person refers or signposts a customer to another person, but provides only that aspect. There is no further involvement in establishing the business relationship or the CDD process. So to round off this section, I'll just emphasise that the code requirements have not changed, and nor has the way in which we applied those requirements. The approach in the handbook also has not changed. We've updated it in December 2023 to try and clarify the expectations of how you apply the code requirements in practice. The handbook clarification and this webinar is all part of our commitment to ongoing education and outreach to ensure firms have the right understanding in this area. We all have the same goal for business to be conducted in a compliant manner. Lucy is now going to talk through some of the scenarios that have been provided to us to put this into context.
Thank you, Ashley. I'm now going to go through a few scenarios that we've come across, and we hope the feedback is helpful for you putting the requirements into practice. So in this first scenario, we have an Isle of Man relevant person, or IOMRP we've shortened to in this webinar. The Isle of Man relevant person is contacted by a USA tax advisor on behalf of their customer to obtain a quote for services. The Isle of Man relevant person goes through the onboarding process, does their risk assessment, etc., and they decide to accept the customer. All the communication and all of the due diligence during that onboarding process is provided by the USA tax advisor. This is a prime example of introduced business. The USA firm is introducing the customer to the Isle of Man relevant person, and they're providing all of the due diligence. They're also acting as an agent or intermediary for the customer, possibly, so you must look through that and consider the risks. The requirements of paragraph 9 would apply here, as the USA tax advisor is an introducer. This next scenario has been posed from the perspective of an Isle of Man law firm. So the Isle of Man law firm is approached by a foreign law firm to provide services to an Isle of Man structure. That Isle of Man structure is administered by an Isle of Man TCSP. The Isle of Man TCSP provides the CDD on the Isle of Man structure to the Isle of Man law firm. The Isle of Man law firm's customer is the Isle of Man structure. From the Isle of Man law firm's perspective, the foreign law firm has acted in a referral capacity. However, if they have provided any elements of the CDD during that introductory stage, then they would be classed as an introducer under paragraph 9. The Isle of Man TCSP has provided due diligence during the onboarding and introductory stage to the Isle of Man law firm, so that is an introducer. The Isle of Man law firm would have to consider also how that Isle of Man TCSP undertook their CDD and whether any third parties were involved in that process, whether or not it was introduced business in that scenario, and also who has ultimately met the customer. We'll cover a bit more about TCSPs and whether or not they may be introducers or third parties in the CDD process a little later. So moving on to this next scenario, we have Firm 1 and Firm 2 who share a common customer. That's UBO, common underlying customer, in the middle of the screen. That common customer now seeks an Isle of Man structure. Firm 1 refers Firm 2 to an Isle of Man TCSP. This is a pure referral. The TCSP and Firm 1 have a long-standing relationship and they meet regularly, so they're able to refer Firm 2 to the TCSP. Firm 2 liaises with the TCSP and they send the application form, the customer due diligence, etc. to the TCSP. The UBO has signed the application form and their ID&V, identity and verification documents, has been certified by Firm 2. They confirm that they have met the customer. Where the TCSP has queries about the onboarding or any aspects of the structure that's to be set up, their queries go to Firm 2. And the responses come back from Firm 2, but as well as that, the UBO, the UBO's lawyer, and the UBO's PA. The TCSP goes on to establish the Isle of Man structure, and the ongoing communication is with the UBO, their lawyer, and their PA. So to break this down and which party acts in what capacity, Firm 2 is an introducer under paragraph 9. They've introduced the UBO to the TCSP, and they've provided elements of the due diligence process during the onboarding stage. Firm 1, who had originally recommended that Firm 2 use the Isle of Man TCSP, has acted solely in a referral capacity in this scenario. It's important to note that whilst the UBO's lawyer is not on the screen, they could be an introducer too if they've provided elements of the due diligence during the onboarding. Think back to the slide about elements of the CDD process. It can be anything to do with the application form, the source of funds, the information and nature about the intended purpose of the relationship, and so on. It's not just the identity and verification. Otherwise, if they provide elements of the CDD process during the lifetime of the relationship, they may be a third party in the CDD process, which is where we talk about paragraph 6.3e of the code. You also need to carefully consider the role of the UBO's PA and whether they're providing elements of the CDD too. So this next scenario, Accountancy Firm 1 introduces a customer to an Isle of Man TCSP. The customer gets tax advice from Firm 1. They want an Isle of Man company. Communications are had between the TCSP and Firm 1. The customer goes on to be onboarded by the Isle of Man TCSP and does their verification of identity through electronic means through an application or a phone app. Queries from the TCSP about the onboarding process, etc., are sent to Firm 1. Firm 1 is able to provide some missing information in terms of the onboarding, the rationale for the company setup, the tax advice. Accountancy Firm 1 is an introducer. As well as having introduced the customer to the TCSP, they've provided elements of the CDD process. They provided information on the nature and intended purpose of the relationship, and that all means they're an introducer during that introductory stage. This is an example of not focusing just on the identity and verification of identity elements of the due diligence process. The customer has actually done their verification of identity through an app directly with the TCSP, but the accountancy firm, Firm 1, has provided other aspects which are captured in elements of the CDD process that we touched on earlier. So in this scenario, a new customer is referred to the Isle of Man relevant person by an existing customer of that firm. The new customer approaches the Isle of Man relevant person directly. So this is akin to a true referral or recommendation from the existing customer to the new customer to seek business with a service provider on the island. The new customer's PA sends the application form and the due diligence to the Isle of Man relevant person, which has been certified by a trusted person who has met them. Once the application for the Isle of Man structure has been accepted and the structure is set up, ongoing communication is with the PA of the new customer. So whilst this may not look to be introduced business on the face of it, as the new customer has come directly to the Isle of Man relevant person on the existing customer's referral or recommendation, the Isle of Man relevant person should carefully consider the role of the PA. They've provided elements of the CDD during the establishment of the relationship. They could be deemed an introducer, or are they an intermediary, a representative, or acting on behalf of the customer? So this should be carefully considered and should be factored into the CRA, the customer risk assessment. You'd also want to think about the ongoing relationship through the customer's PA in the customer risk assessment. So a further area we wanted to just touch on is where a customer might be introduced by a TCSP who provides director services to that customer or trustee services to a trust. In this example, an Isle of Man TCSP approaches a relevant person, such as a bank or an investment business, to act for a company for which they provide directors. The TCSP provides the due diligence for the company and for the directors, which are TCSP staff acting as directors of a client entity. It's very important to note that this could still be introduced business. Whilst the Isle of Man relevant person's customer may be the legal entity, the directors of that customer are in those positions through service provision and are not truly the underlying customer. It's not in the spirit of the code or what paragraph 9 is looking to achieve by stopping just at that point. It obviously depends on the circumstances of each case. Some points to consider. The TCSP is providing the due diligence in their capacity as service provider. It is coming from the TCSP and not from the customer itself. Therefore, the TCSP is a third party. If correspondence is all between the employees of the TCSP and the Isle of Man relevant person, then we don't believe this information is being provided by the customer itself. And again, that would mean the TCSP is an introducer. To consider as well, it's not as simple as having met the directors means having met the customer. Just meeting the TCSP representatives or who are acting as directors of a client company is not meeting the underlying customer. You need to think beyond just the legal entity or legal arrangement. Think about what paragraph 9 is seeking to achieve and what Ashley covered at the beginning around the purpose of bringing paragraph 9 of the code in. It was queried recently about the sharing of or reliance on due diligence between parties where electronic methods are used. So I'll start by saying the code is technology neutral, as is the handbook and the supplemental information document. In the supplemental information document, we've tried to provide as much guidance as possible on electronic methods and sources, as well as the more traditional methods that you might think of. So the example given goes like this. An Isle of Man relevant person onboards a customer and verifies their identity using electronic methods. The Isle of Man relevant person then introduces that customer to a bank. The Isle of Man relevant person is unable to share or provide traditional verification documents, such as a passport or driving licence, as they've used electronic methods to verify the identity of the customer. The Isle of Man relevant person may be able to produce and provide a report detailing that the customer's identity has been verified using those electronic methods. So the question raised in this scenario is whether this report would be sufficient. So in terms of our feedback, there is no hard and fast rule or clear answer on this scenario. The bank has asked whether a report from the Isle of Man relevant person would be acceptable. And that's really not something we can comment on, as it's up to each relevant person to determine what they're prepared to accept on a risk-based approach for customer due diligence. Each relevant person needs to decide what they're comfortable in accepting as sufficient for customer due diligence and the reliability of any report or method that it might use. Each firm will have a different risk-based approach and a different risk appetite, and it may be that group or parent protocols drive some of that appetite. So in short, there's no hard or fast answer. It's up to each firm to determine what they're prepared to accept. You may recall that when paragraph 9 was brought into the 2019 code, we issued a standalone guidance document in October 2019. This detailed a transitional arrangement as shown on the screen. We allowed 6 months, so up to April 2020, after which new customers must be onboarded in line with paragraph 9. This 6-month window was to allow firms to prepare their procedures and controls, processes and risk assessments to deal with the new requirement. In terms of existing customers, you'll note that it said the paragraph 9 requirements would kick in at a trigger event or on review of the CRA. So, for example, if you had a standard risk customer and their CRA is due to be reviewed every 2 years, the next CRA review falling due after April 2020 would be required to include a review to determine if there were any introducers and an introducer risk assessment be carried out as appropriate. So this very much links to paragraph 10 of the code, continuing business relationships, which relates to existing business relationships and the application of new or revised code requirements. There's a clip on the screen of the transitional arrangement that we brought in 2019. We've been asked what firms should do if they can't determine whether there was an introducer, or if the introducer no longer exists, or if they no longer have contact with the introducer. This is more likely with aged relationships or more historic connections. And we realise that you can't risk assess what you don't know, but you do need to show that you've endeavoured to see if there was an introducer and endeavoured to risk assess them. It's important to document all the steps and all of your work to show your thinking and rationale. Similar problems may arise with trying to determine who has met the customer. Again, best endeavours must be demonstrated if it's a really historic relationship. However, there are some things you could consider taking steps towards which may mitigate the risk or any unknown risk, such as meeting the customer. Could you meet them now? Or refreshing your due diligence. This could include the source of funds information, up-to-date occupation details, and not just the identity and verification of identity. I'll now hand back to Ashley, who's going to talk about the outputs of this work.
Thanks, Lucy. As we've mentioned already, this is very much a period of education and outreach for us in this area. We want to work with firms to improve understanding, and we really would emphasise that if you're struggling with a scenario, please do contact us. Feedback is essential so we can determine if there are gaps in this understanding. Also, following any queries raised on the back of this webinar, we'll look to issue a frequently asked questions document. We may also determine additional handbook updates are needed, and we will try to do that as soon as we can. If you do have any questions or any scenarios, please get in touch with us on the email address that is shown on the screen, and we'll come back to you as soon as we can. So thank you all for joining us today, and we hope this webinar is helpful